SJC-10944, Commonwealth versus Jones.
Mr. Votero, good morning.
Good morning. May it please the court. My name is Brett Votero, and I represent Ryan Jones. Before I discuss the issues relating to my client's competency, I'd like to take just a few minutes to discuss our request that this court take a look at Article 26 and the Eighth Amendment as it might be extended in this case. You know, the last 15 years has demonstrated that the decisions of the U.S. Supreme Court and of this court make it clear that the prohibition against cruel and unusual punishment does change as we become a more civilized society, as we learn more. So consider this just briefly. In 2002, the Supreme Court ruled that we cannot execute the intellectually disabled. In 2005, the court ruled that we cannot execute those who commit murder when they're juveniles. In 2010, the court ruled in the Graham case that you cannot impose a life sentence without parole for a non-homicide offense for juveniles. And in 2012, the court ruled that it is cruel and unusual to impose a mandatory life sentence without parole on a juvenile convicted of murder. And this court, when it dealt with that issue in Massachusetts, went further and said that under Article 26, you can never impose a life sentence without parole on a juvenile. Those decisions all reflect those unique capacities of juveniles and the unique challenges of the intellectually disabled. The quote that I've included in my brief from the dissenting opinion of the Virginia Supreme Court, I want to read the last sentence. A moral and civilized society diminishes itself if its system of justice does not afford recognition and consideration of those limitations for the intellectually disabled in a meaningful way. And so let me be clear what I'm asking the court to do. I submit it is constitutional to impose a life sentence without parole on the intellectually disabled. But what is unconstitutional is to make that mandatory. And that is the distinction which this court drew in the Dyachenko case, that with juveniles, we cannot say forever and absolutely that this young person should be incarcerated for the remainder of their life. And I want to suggest that when it comes to the intellectually disabled, because we know from our collective experience in the legal system that covers a wide range and a wide spectrum of disabilities. It covers a wide range of culpabilities. It might well be appropriate to impose a sentence of life without parole. But what I ask this court to do is to extend the jurisprudence to take a small step, but one that is very significant to those who have an intellectual disability.
That may be a meritorious argument. However, for your particular client in this particular case, it seemed, as I read it, that it was a very calculated, thoughtful move, and that he was able to hold a job all that time and did great at it, and was angry and vengeful and mad.
And this is where we come to this issue of the ability to reason and to make rational decisions. My client, at the age of 28, with no significant history of any kind in terms of criminality, reached the conclusion that because his boss at this restaurant would not allow him, would object when he put metal pans through the dishwasher instead of washing them by hand, because of that reason, he concluded rationally that he had to kill her. It's what we mean when we say this is a senseless act. It doesn't make any sense, and it is indicative of the problems that he suffered. Ryan Jones might, if he were properly tried and received a fair trial, he might be sentenced to life in prison without parole. But he should not be denied the opportunity to have a judge consider an individualized sentencing for the reasons articulated by this court and the U.S. Supreme Court. He should not be denied that opportunity.
But your client, to my knowledge, is not intellectually disabled. His IQ was, I believe, in the low, medium range. What his problem was the pervasive personality disorder, sort of part of the autism spectrum. So even if you are right, why is this the case for us to do that?
Well, my client is, the court is correct. My client is not meet the definition that we're using of intellectually disabled, which is our new term for mental retardation. He is developmentally disabled, and of that, no expert has ever disagreed. His intellectual functioning depends and has some pretty significant variations. So let me turn to the heart of my argument on this appeal, and that is that he was incorrectly found competent to stand trial. And in doing that, there are two facts I want to emphasize. The first is, Ryan is autistic. That's true. That's not disputed by anybody. But the second fact that's important is Ryan suffered, when he was 6 months old, an organic brain injury. He had a brain bleed. He had spinal meningitis, and there's clear evidence of brain injury. Now, Judge McDonald makes a reference that the autism is likely a result of that. I'm not sure there's any basis, or that any basis has been offered in any of the expert reports, that there was a link between his brain injury at 6 months old and the autism. We all know there are many people with autism without that particular history.
Was Judge McDonald authorized to reject the two experts, or kind of the Commonwealth expert and the defense expert? Was he authorized to do so and to come up with a contrary finding that he was competent?
Well, I'm not sure I'd use the term authorized, but I would suggest that he did not have a basis on which to do that. He did not have a factual basis.
Do you agree that it was within his authority to do so?
Well, I know that this court has said that a court is not required to accept the testimony of experts on either side of an issue. But there is a difference when a party has a burden of proof to prove competency, to say, you're free to go about this without expert testimony. A judge is free to draw conclusions on competency.
I don't want to put words in your mouth, but you're whatever the standard is, and even if Judge McDonald had that authority, your argument is the evidence was insufficient for him to make that finding.
That's correct. Yeah, he did not have sufficient evidence to do that. Now, I'm emphasizing that
I know you focused on Judge McDonald, but closer to trial, you had Judge McGuire, I believe, making a finding of competency, and then during trial, after the dog petting incident, you've got Judge Nickerson making a finding of competency. So why do we focus on Judge McDonald as opposed to Judges McGuire and Nickerson's findings?
Because both Judge McGuire and both Judge Nickerson drew their conclusion on the idea that nothing, and I'm going to quote Judge McGuire, "The situation has not materially changed since the competency hearing by Judge McDonald." Both accepted that was a valid finding, that Judge McDonald had found him competent, and because the situation hasn't changed, we can say he's still competent. So I suggest that flawed as it is, Judge McDonald's competency finding continued to impact the view of the judges who conducted, appropriately so, an examination closer to the time of trial. But let me point out one of the key facts about this case. Unlike some cases where competency has been raised, and there's an issue of, well, the defendant wasn't on his medication, or now he's on his medication and it's improved. The experts in this case, both the psychiatrist produced by the Commonwealth and Dr. Ebert, agreed that Ryan Jones' condition isn't going to change. It's immutable, it's long-standing, and it's not going to change. What they were focused on, and what even Judge McDonald questioned, and certainly the judge before him, is, well, can it be improved? Can he learn better? And this is, I want to come back to I mentioned two facts that were key. One is, autism plus the organic brain injury. And I want to point specifically to that testing that was done by Dr. Hebben. You know, the testing shows low, borderline, low average in many areas except one. And I've cited in my record, there's one area where Dr. Hebben says he's scoring less than the first percentile. And it has to do with his ability to hear. Verbal comprehension, I think, is the subtest. And this is a critical aspect of being able to assist your counsel. Note, as Dr. Ebert does in his final conclusion, in as many times as I've explained to Ryan what not guilty by reason of insanity means, Ryan's conclusion is, so I have to prove that I'm sane, right? It doesn't make any sense. You know, we're all familiar with Oliver Sacks and some of the unique things that can happen with brain injuries. The man who mistook his wife for a hat, seeing music, hearing colors. In Ryan Jones' case, in the record, we have this subtest score of less than 1 percentile, which matches exactly what Doctor is saying in this case. He can seem okay, but as you get more into it, as you learn more, you realize he is not rationally processing the information. And I think the best testimony that the doctor gave was when he said, you know what, I've been in court on 3 occasions with Ryan, and it's not clear to me that he's even hearing what's being said, let alone processing it rationally.
Does Judge McDonald also draw the conclusion that there's malingering involved, given his inconsistencies in his understanding of the legal process?
I think you're absolutely correct. In fact, I think that's what Judge McDonald felt was very significant, despite the fact that all of the experts said, you know what, whether he's malingering or not isn't changing our assessment on his ability to reason, and this makes sense. Because we know that even a young child standing in front of a broken cookie jar is going to say, no, I didn't do that. It's a natural act in some cases. So I think the judge, when he finds malingering equals competency, has conflated criminal responsibility questions with competency. And so this is where, when you look at the record of what Judge McDonald had, both experts said he's not competent to stand trial. He's not able to rationally consult with his attorney to understand what's going on. And even if you look closely at the record of the very first competency examination, where Ryan is found competent, what you read the examiner saying is, there's things he's not getting, but by the time this case comes to trial, he should be able to understand this. And so what we know in the history of this case is you can explain it all you want. But because of his brain condition and his developmental disorder, he's not processing it rationally.
So are you saying he'll never be competent based on his history and the organic brain trauma?
It's a good question, and I can't answer that. But that is the question that should have been asked. In other words, when he was found not competent to stand trial, that judge said, I'm going to continue this for 6 months. What was left undecided, not part of the record there, is whether it could be addressed, because there was disagreement on the experts on whether he could, with proper education, become competent. That disagreement continued even in the hearing in front of Judge McDonald. I would like to say that there's enough in the record, but there isn't. And so what I suggest the appropriate outcome in this case is this young man's conviction should be reversed. It should be remanded. And I want to suggest to you that while the case may not be quite ripe for this, there was not sufficient evidence for Judge McDonald to conclude that he was competent.
Can we talk about that for a moment, please?
Yes.
Obviously you are correct. Just because someone's malingering doesn't mean that they're competent. No doubt about it. But what the judge could do is listen to the expert or experts and say, well, I'm going to take what the expert has to say about this issue and that issue, But as far as the ultimate conclusion, I don't credit it because the basis for its malingering, and in my own observations and evidence independently of the malingering issue that I do credit that the experts say, I find by a preponderance of the evidence that he is competent. So you are 100% right, of course, that you can malinger and not be competent. But the fact that he thought that they were malingering means that he might not have credited their ultimate conclusion and based his conclusion on other evidence.
That would be entirely appropriate. Were there other evidence? And that is why I think this court meant what it said in the Vuthei Seng case in 2005. An expert cannot form a credible opinion as to somebody's competency without examining him. Well, if that's true, how can a judge whose only evidence is the experts, which if we're going to remove that from consideration in a moment, okay, how can a judge determine competency? The only other evidence before him was testimony of co-workers of his behavior years before, where he was able to discuss baseball and things of that nature. Not the kind of issues that you have to understand and rationally discuss with your attorney in a criminal trial. So in Vuthei Seng means what it says, then you can't establish competency by mere cross-examination alone. Now, my sister has cited a case, I think it's Di Domenico, and I respect the holding in Di Domenico, but let's look closely at it. In that case, the judge had ample evidence from which to conclude the defendant was participating to a great extent in the trial over the objection of his counsel, but he was asking questions.
And Domenico is well before saying anyway.
Yes, it is. It is. And this court has, I think, if you look at some of the decisions even on criminal responsibility, you've cautioned the Commonwealth, listen, you proceed at your own peril if you try to establish and meet your burden of proof without an expert. Yes, it can be done. But criminal responsibility, where a jury can draw conclusions about how your brain is working based on all of your conduct, I suggest is different in kind from competency to stand trial. If he's not perceiving, if he can't rationally assist his attorney, and the best example of that is this exchange with his counsel, with the expert on insanity. Okay, so I have to do what I can to prove I'm sane. No, that doesn't make sense. Again, it's consistent with this organic issue that he has.
Isn't that what a lot of lay people think? That's why we have to take such great pains in our instructions to say, just like in self-defense, and flip the burden around. I don't see that as such a bizarre belief that would render someone incompetent.
Well, I'm not hanging my hat on that. It appears in the report. I think it's significant. But in truth, when you read Dr. Ebert's report, it is simply one of his cited examples of how Ryan is not retaining or understanding the key things that are essential.
If I can take you back to an earlier question by Justice Gaziano.
Yes.
What is our standard of review? Is it clearly erroneous? Is it abuse of discretion? Is it that the evidence was insufficient as a matter of law to permit a finding of competency? What is the standard? I don't recall from your briefs any discussion of that.
I'm not sure that I included that in my brief, and that's a good question, although I'm actually confident that whether it's any of those standards that you say, when I have two experts, in theory, opposing experts.
I know you say you'll win on any of them, but it would still be helpful to know which one is the one we've used in the past.
Yes. Well, I can't answer that here. I'm happy to follow up with a letter to see if I can locate that. But I certainly see that this is a case where there was not evidence in the record, as we see in Vuthei Seng, that would warrant that. It was minimal at best. And it can only come, if we disregard the experts, it can truly only come from these co-workers, because there is no interaction between the judge and the defendant. So short of observing a silent Ryan Jones at counsel table, unlike Domenico, there's nothing that can be added to the judge's assessment. And I note as well, and I see I'm running out of time, that I am concerned about that last reason that Judge McDonald cites, where he says, look, I know this is a difficult case, but as important as the public the public interest in putting somebody charged with a serious crime to trial equally important are these constitutional rights. I want to suggest to you that there's a pretty clear suggestion that if this were just a B&E or a shoplifting, the result would be different. And that's not the way the constitutional protection should be afforded. So I thank the court for its time, unless it has other questions.
All right, thank you.
Thank you.
Ms. Stern?
Good morning, Your Honor. Shoshana Stern for the Commonwealth. I did go looking this morning for the standard of review this court applies to determinations of competency, and actually I didn't readily find one. Obviously, there has to be one. There generally is reference to the fact that it's preponderance of the evidence and there's substantial deference to the findings of fact of the lower judge, but the cases I came across essentially said, the evidence supports this finding, but didn't get into brass tacks of, exactly where's the edge. There may well be a case out there. It is actually...
Is it a finding of fact or is it a discretionary determination?
I did run competency and discretion through Lexis and didn't actually find anything on point, which may well suggest that's not the standard, but I have to admit I did not get beyond that this morning.
And under federal law, is it also a preponderance standard?
I don't know, Your Honor. I'm sure that our standard is not accords with the requirements of the federal Constitution, but beyond that, I don't know.
I should know the answer to this question, but did Judge Nickerson at trial make specific findings of fact on competency?
On competency, he said that he had been watching the defendant carefully throughout the trial, as was his practice.
I remember that.
Yes.
But did he dictate any findings of fact as to the basis for it?
He talks about him appearing to be aware, not appearing to be distracted by an imaginary dog. He gets into the details of what he observed, and I think he says it's in accord with the with Dr. Logan's contemporaneous examination of him and opinion that he wanted the court to believe that he saw an imaginary dog, but he did not actually literally see one. So they appeared to be in accord. He had several paragraphs, I think, of findings in the record, some of which are more directly a finding and some of which are more observations.
But I think Judge Nickerson also made clear, and knowing Judge Nickerson, I would expect he would, that he was familiar with the earlier findings of the earlier judges.
Yes, Your Honor.
So he inherited
Yes.
the findings that had been made earlier.
He did. He also, I believe, made clear in his asking Dr. Logan to observe the defendant that he was aware that there were prior proceedings, but that they did not, that competency is contemporaneous. It has to be made today. It could have changed. We're not bound by, none of us are bound by the prior decisions, even though they're informative.
Now, do you agree with your brother that Judge McDonald did not have any finding of any expert that the defendant was competent?
Well, he did not have a official, I as the expert give my expert opinion that this defendant is competent. That is true. As I argue at length, he used large amounts of information generated by the experts. Competency, as has been made clear in the case law, it's a legal standard really rather than a medical or scientific one. Obviously, those things are relevant, but it's not really something anybody other than the judge can give an authoritative opinion on. That the opinions of the experts, I think, are extremely useful, but it's not the sort of thing that it would be reasonable necessarily to have the judge bound by. That it's not, it's not like sexual dangerousness, which is also a legal concept rather than a medical one, but where you have to have at least one expert saying the person is. It's not thumbs up, thumbs down from the perspective of the subject matter experts. And ultimately, the question is, does this defendant, colloquially appear to get it, but it doesn't map on and is not required by law to map on to anything other than standards generated by judges and lawyers and applied by them. I think that on the subject of competency, this court will watch the defendant's police interview. I would argue that it is very instructive in terms of getting a sense of what the defendant did and didn't understand.
Is that in front of Judge McDonald? Did he consider that?
I was not, I know the experts watched it. I don't know for sure whether he personally did, off the top of my head. And obviously,
I don't think
What?
I don't think he referenced it.
Yeah, I don't think you referenced it, no, Your Honor. Judge Nickerson obviously would have seen it because the defendant started petting the imaginary dog at the time it was being played for the jury in presumably a somewhat full form. But you see the defendant interacting with the police at a point where, you know, he knows he's potentially in trouble, but he doesn't know that he doesn't know he's going to be caught necessarily. And he's very, I would argue, careful about what he does and doesn't say. And this was a large part of the Commonwealth's closing argument. He talks about, he has the entire cover story. He's injured himself to look inferentially like he's been attacked. He's very clear, I'm not the killer. You think I'm the killer. He keeps referring to the person as the suspect. He shows no confusion about permanency of death. He does ask once if the victim survived, but he appears to be clear that I witnessed a murder. It was the worst thing I've ever seen. This is bad. The police ask him, you know, is telling the truth wrong? Yes, well, tell us the truth. I'm telling you the truth. He won't back down for anything, but he doesn't just obstruct. He comes up with explanations for everything he's asked. And I mean, he does not outsmart the police, but I would argue from a sort of 33 type perspective, there are many defendants who don't have his limitations who do worse. He's very astute for the most part at figuring out the significance of what the police are telling him, even if he can't really explain it. They ask him about the dishwasher. He says, and he said, do you put anything in that you shouldn't? And he sort of has a like, well, what the hell? Yes, I do. And a sort of, you know, why wouldn't I admit that? It's just a little, you know, I know I shouldn't, but. And then they say, does anyone ever tell you not to put the pots and pans in the dishwasher? And he names the other manager and not the one who he just killed over this. And so he knows, one could infer that is, he doesn't want to put himself anywhere adjacent to the facts that actually led to this. He has, again, he is very able to accommodate, and I don't know if this came in at the trial, but he calls his father to tell him what happened. And he gives him, it's also a sort of carefully edited, differently edited version that doesn't really give anything away. He shows a large amount of nuanced understanding of his circumstances, of what will get him in trouble, of roughly why it will get him in trouble, and that a person should get in trouble for this. And that, again, despite his limitations, he is actually very functional in a lot of understanding of murder and police investigations and et cetera, that suggests an ability to think strategically that is highly relevant to competency and confirms the various other findings.
And how do we look at that statement? So that's a statement that an expert in front of Judge McDonald reviewed. So,
Yes.
And Judge Nickerson would have seen it
Yes.
at trial. And it's part of the record here.
Yes.
So as far as determination of competency, how are we using that?
Well, again, as far as I've, I think it supports the correctness of the determination, particularly given that there was the issue of malingering. But I think that
Actually,
Yes.
is that part of a factual finding? That's what I'm trying to get at. Or can we look at it independently? What do we do with that?
It's a fair question. Obviously, I think anyone who saw it, any judge who made a competency determination afterwards, presumably would have had reason to take it into account. If McDonald did not see it, it would not go into whether he personally made factual findings that were reasonable. However, I think it would support an idea that his factual findings were reasonable, essentially. That, you know, first we would argue that it's supported by the evidence that was directly in front of him. It went into the experts' discussions, but on sort of more of a broader sort of Justice 33 sense of, you know, was this the right result? Was this a competent defendant who was tried? It would go less to whether he specifically erred than to sort of whether justice was done and whether this court is satisfied that, you know, in addition to meeting the standards of review, for the specific determinations that were made here. And again, this was only the second of 5 judges to speak to the defendant's competency, which was a very carefully litigated issue that everyone took very seriously, that not only did it meet sufficiency standards, whatever precisely they may be, but that it was, in fact, that there's no grounds to be concerned that it was not the right result, that there's no sort of against the weight of the evidence of anything. I think it would be relevant to that, relevant also just to the correctness of the jury's verdict, that, this is somebody who knew what he was doing.
Can you just address briefly your brother's argument that, or request that he started with in the beginning of his argument, that we extend Diachenko to developmentally or to intellectually disabled people?
Well, as the Chief Justice pointed out, that this defendant is not intellectually disabled in that sense. I think that in general, these are issues that are evolving socially, but this court, it has not been fully litigated in terms of consideration by this court. This court declined to extend Diachenko to mentally unstable defendant in Colton in May, and I think that insofar as Diachenko is very much founded on not just ideas of abstract justice, but the juveniles specifically are very different from adults and on very specific juvenile brain science. This defendant does not really share any of those qualities. He wasn't impulsive. He wasn't easily influenced. He, according to the defense, he has no capacity to change. I think that that's subject to some dispute, but essentially he does not, his arguably somewhat unusual circumstance does not align with anything that directly underlay Diachenko, except for a general idea that, there's some categories of defendants who you might want to have be parole eligible. I'm not sure parole eligibility would really be a obvious remedy in this case, according to the version of facts adopted by the defendant, that, if you take the defense version of the case, he's not going to be any different in 15 or 25 years. Again, that's subject to dispute, but I would argue that this is not really a good fact set to be investigating that question, even if the court were looking to.
Thanks.
Now, your brother says that it all rests on Judge McDonald's findings, and that if his are unwarranted or an abuse of discretion or clearly erroneous, that's essentially the foundation, and if that collapses, everything else collapses. Do you agree with that?
I do not agree with that, Your Honor. I think that McGuire did essentially, his ruling was, I see no reason to change it. But first of all, there was some investigation there. I don't think if it were obviously crazy, he would have upheld it. I think it can be concluded that he applied independent thought there. And Judge Nickerson had the opportunity of observing the defendant through the trial, called the hearing, made his own determinations. At that point, there was arguably significantly more, as Dr. Logan said at that time, that the defendant appeared to have an idea that if he could appear to have essentially more issues, it would help his case. And I think there was a growing amount of evidence that he was, from which one could infer that he was trying to exaggerate or even grossly exaggerate his limitations out of a calculating decision that this would be better for him legally, which again is in some ways arguably evidence of competency itself that he is able to determine that this would be better for his case if he could pull it off, suggesting that he actually sort of does understand, outside of the other evidence, the significance of an insanity defense. But again, I think that each time this case came up, more evidence accreted, more experts, more deteriorating conditions by a defendant who should not have deteriorated. And again, Judge Nickerson made detailed observations, made detailed rulings. They accorded with, Dr. Logan saw the defendant twice, both for, I think, McGuire's evaluation and for Nickerson's. And she recommended that there was no reason to do another full evaluation. But again, I think that suggests that this was all within the realm of what seemed like a reasonable conclusion. I know Dr. Ebert was of the impression that this was a very stealth condition you could very easily miss, but I don't think that the evidence suggests that other experts really needed to agree with that, that this was not somebody who would give all appearances of understanding, but not, essentially. There are no further questions?
All right, thank you.
Commonwealth rests on its brief. Thank you, Your
And
Honor.
we'll take our morning break.